Today's presenter, Mitch, is a human resources coordinator at Ironwood and brings over 8 years of HR experience in the private sector. Prior to joining the Ironwood team, Mitch worked for two large international corporations within the security and tech industry. Mitch's experience within multiple facets of human resources, specializing in employee relations, investigations, compliance, ADA, FMLA, and training and development. Mitch has over 3 years of direct employee relations, investigative experience within both union and non-union environments. Mitch has a Bachelor of Science in Psychology from Washington State University in Pullman, is SHRM-CP certified or SHRM certified, and is a licensed private investigator in the state of Texas. So without further ado, Mitch, I'm going to give you the floor.
Sounds good. Thank you, Becca. So yeah, today we're going to be covering the Americans with Disabilities Act, or ADA, and how that interacts with HR. We're going to be providing an overview of the ADA's impact on the workplace and really diving into that accommodation process. So before we get too much further, I do just have a quick disclaimer. Like was mentioned before, this is being recorded. If you have any concerns or objections to being recorded, please reach out to the Blue Springs team. And then another disclaimer. So with any sort of training we do, it's going to capture kind of where we're at currently. The content in this is designed based on kind of the best practices as they exist currently and the laws as they exist currently. As we've seen throughout the year, laws can change pretty quickly. So it's always a good idea to take the time to double check the current regulations if you are navigating through a situation. It might be worth reaching out to a legal professional if it looks like there's a possibility for litigation and things like that. So the training today is based on those kind of best practices. It's not considered legal advice. So again, we just highly recommend that as you start navigating into those situations, or if you encounter a tricky situation, it's always a good idea to just double check the regulations and make sure nothing snuck past you or gotten updated that you weren't tracking on. So before we dive into the specific requirements, I want to provide kind of an overview of what the Americans with Disabilities Act is at a high level. So it was passed in 1990. Essentially, it prohibits discrimination against individuals with disabilities in all areas of their public life. So things like handicap parking. I'm sure you've seen the push buttons on the outside of buildings so that the doors will automatically open, things like that. There's Braille signage requirements for certain spaces. But within the work environment, it applies to employers with 15 or more employees, and it provides some additional protections for disabled individuals. The largest component of that, aside from not discriminating against individuals with disabilities, is the accommodation process, which we'll be diving into a little bit, well, a lot more in detail later on. But the core element of it really is just making sure that there's a fair playing field for everyone, whether or not they have a disability. So why does ADA compliance matter? Well, first and foremost, there are some significant penalties if you're violating the ADA. When I was kind of preparing for this, I was looking at one claim. It ended up being a settlement for about $92,000 for UPS. Essentially what happened in that situation was they had an individual who needed a sign language interpreter for meetings. And UPS, despite the employee making repeated requests for it, never tried to engage the employee in the accommodation process. That one ended up scaling all the way up to the Supreme Court before it was settled. So there wasn't an official ruling on it, but they ended up paying out, I believe it was $92,000 just in damages. That's not including legal fees or anything like that. So the penalties are pretty significant, and there's a lot of financial implication if you're not following the ADA process. Additionally, by engaging in that ADA process and making sure that you're considering those individuals that may have disabilities, you're broadening the talent pool that's available for you. If you can effectively implement an accommodation program, you'll see a significant return on investment, because you'll be able to take those individuals that they might need a little bit more help to reach the same performance goals through those accommodations. But at the end of the day, you'll also see that return on investment in those situations. And then it'll also help your company's reputation. So 92% of consumers view companies that hire people with disabilities more favorably. So there is going to be that direct impact on your brand and market position, which will ultimately benefit the company in the long run. So in addition to the original Americans with Disabilities Act, there's also the Americans with Disabilities Act Amendments Act of 2008, or the ADAAA. But typically it's just referred to as the ADA and kind of combining the two. What this did was it took the initial scope of the Americans with Disabilities Act and really expanded it out to kind of reflect the Supreme Court decisions that had taken place since the Americans with Disabilities Act was actually passed. First and foremost, it expanded the definition of disability to include more conditions. So in doing so, it expanded out to less visible disabilities. So things like mental health conditions, so depression, anxiety, PTSD are now more clearly covered, along with chronic illnesses. So things like disability or diabetes, epilepsy, multiple sclerosis, things like that. It also emphasizes an inclusive interpretation to try and protect more employees. And then really it made it easier for individuals to identify and establish their disability status. So you've heard me say disability a lot already, but it's important to understand who is protected because not every injury is necessarily a disability, and not every disability may necessarily qualify under the ADA. So the legal definition of a disability under the ADA is a physical or mental impairment that substantially limits one or more major life activities. So what that means is these are substantially impacting the individual. It's not just, hey, we have this going on in the background. There does need to be that impact on their life activities. And this can include things like visible disabilities. So if somebody is, for example, missing a leg, like I had one of my employees previously, that's kind of obvious. Things like blindness, deafness, if they need mobility aids, so they have a mobility impairment, could potentially indicate a disability. But not everything is visible. Things like diabetes, epilepsy, mental health disabilities like depression, anxiety, ADHD, the autism spectrum, things like that. You can't just look at somebody and see those. But the ADA does have those protections in place for that. So another aspect that I see a lot of people get confused on are temporary conditions. So let's say you have an employee, they're working at home, they fall off a ladder, they break their leg. That broken leg by itself would not typically be covered. However, if they break their leg and then suddenly they develop a condition that causes long-term impairment, like the bone didn't heal correctly, and now there's mobility issues as a result of it, that would potentially be covered. However, the broken bone itself, because it's more of a temporary condition, would not. So the ADA protects individuals who have a disability or a qualified disability, but there's also requirements for the job itself. To be qualified, a person must satisfy the job requirements of the position. So that means the education, the experience, the skills, etc. But they also have to be able to perform the essential functions with or without reasonable accommodation. So, for example, a software developer who has hearing loss and they need to use captioning technology during meetings, they'd be qualified because they can still perform that role. They can still perform the essential functions, they can still code, they can still communicate. They just need a little bit of help to do that. Tying back to my example, so I did have an employee, he was a mobile security officer with a prosthetic leg. In his case, he needed additional breaks in order to do some of the foot patrols that were required. So we were able to work with him and accommodate that. However, if we had an employee who was severely visually impaired to the point where they couldn't obtain a driver's license, they wouldn't be able to perform the essential functions of that role, which required operating a motor vehicle because they couldn't get licensed. So in that case, they wouldn't necessarily have full protections there. But in a situation like that, it's still worth assessing if you have alternative positions available. So if the employee may not be able to drive a car, you can still look at, do we have an open position available where they don't need to operate a vehicle? You don't necessarily need to create a position for them, but if you have an open position, it's a good idea to take a look and assess that before you start looking at possible termination. So some of the common misconceptions about disability in the workplace, things like only wheelchair users are protected by the ADA. Well, that's false. At the end of the day, the ADA covers a wide range of conditions. This could include anxiety disorders, diabetes, potentially cancer, or many other things. Another tricky one is when it comes to substance abuse. So potentially, if somebody is addicted to a substance, they can potentially have some protections under the ADA. So where that gets a little bit tricky is it doesn't cover the actual use of the substance, but if the employee needs some additional leave time to, for example, attend rehab, things like that, that's potentially covered. However, it does not protect them coming to work intoxicated or under the influence. Uh, employers can ask about disabilities during interviews. That's another pretty common myth. You need to tread very carefully when navigating through that. Pre-offered disability-related questions are prohibited. You must focus on the ability for the employee to perform their job functions. For example, you can ask if an employee or a potential candidate can perform the essential functions with or without accommodations. But you do want to avoid asking about specifics of their disability prior to hire. Reason being is, let's say you ask about it and then you decide not to move forward with that candidate. Well, now there's going to be potential evidence that you were asking about their disability and that they weren't hired. So it's going to be a lot harder to justify that that decision was not made in a discriminatory manner. So the safest option is just don't ask about disabilities. And then another common myth is that accommodations are always expensive. So according to the Job Accommodation Network, about 58% of accommodations don't cost anything, while the remainder are typically under $500. Um, I've seen a lot of them where it can be solved with something as simple as telework or adjusting their schedule or relatively minor accommodations that don't typically cost a lot. Yes, you do hear about the stories where companies were on the hook for $100,000 for an interpreter or things like that, but those are more the exception rather than the rule. And typically accommodations are fairly affordable. So I've also mentioned the accommodation process, but I want to dive into that a lot more in depth because that's really the core of the ADA process. So the accommodation process, it's really where you're engaging with that employee and their doctor to figure out, okay, what's the disability? How is this impacting your work? And how can we help you meet the objectives of your role? Um, Another common misconception is that the ADA requires lowering the bar for performance. That's not really the case. A lot of the times, the accommodation process isn't to lower the bar to where they can meet it, but more providing the employee with the tools necessary so that they can reach that bar. So reasonable accommodation is any change to the job application process, work environment, or the way things are customarily done that enables a qualified individual with a disability to apply for and secure employment, perform essential functions, or enjoy equal benefits and privileges of employment. This could be something like an ergonomic workstation and equipment that allow the employee to perform their role. In some cases, it could mean flexible schedules or remote work options if those are available and can be done. It could mean communication assistants or interpreters, or it could be modifying training or reference materials. I had one employee who he had a learning disability, so because of his disability, he struggled with written tests. So we were able to accommodate him by providing a verbal test. We weren't lowering the bar. He still needed to know the information. We just shifted how we approached that so that we could provide him with the same opportunities. So the interactive process, like I touched on before, it is really a collaborative approach. The company should be working with the employee and their doctors to really come together and find an accommodation that works for everybody. So first thing, you got to recognize that there's an accommodation request. A lot of the times employees aren't going to come out and say, hey, I need an accommodation for my disability. A lot of the times it's going to be things like, hey, yeah, I had a back issue previously and I'm struggling with this area, or something more vague, or hey, my ADHD makes it harder for me to focus. So in situations like that, it's really on managers and supervisors to recognize, hey, this could be an ADA accommodation, and then reach out so that that process can get started. From there, you want to gather information. You want to document the disability and limitations. So in a situation where it's harder to see the disability, so a lot of the times with mental health situations and disabilities of that nature, you're going to need that medical documentation, but you want to make sure that you're not being overboard. You don't need their whole medical history. You don't need genetic information or anything like that. Typically, the way that I'd approach that is you send them to the doctor and say, hey, request from your doctor a list of what your restrictions are and how they impact your job description. I'll send them with a copy of their job description so the doctor can refer back to that. From there, you want to work with the employee to try and find ways that they can be accommodated. It may not always be the first accommodation that gets thrown out there, and you don't necessarily need to accept the first proposal that the employee has. You need to look at it from the company standpoint of, hey, does this make sense? Are there any safety implications? Things like that. I had one where an employee, he had a existing back injury that never healed correctly. So as a result, he struggled with tying his shoes. Well, we were at a site where we required specific boots because it was a construction site and they needed to meet a certain safety standard. Well, the employee needed slip-ons, boots were laced. So we started working with the employee's doctor. I was working with the uh, our point of contact with the client to try and find a way that we could eventually accommodate that. And we were able to identify a pair of shoes that were lightweight enough, they were slip-ons, they met all his requirements, but we were also able to make sure that they met all of the safety requirements that we needed for that location. So there's potentially going to be a lot of back and forth in there. Once you've identified an accommodation, you want to choose the accommodation that you're implementing. You want to be documenting everything throughout this process, what was requested, what was considered, if something's turned down, why or why not. That way you always have it to refer back to. But once you've got that plan in place, you can implement it, document that it's accepted, being implemented. You may need to train supervisors and managers on the specifics of the accommodation itself. They don't necessarily need to know the medical information behind it, but they do need to know, okay, if John Smith is being accommodated with additional breaks or a flexible schedule, supervisors need to be aware of that. And then from there, you want to monitor and adjust. Sometimes an accommodation will look great on paper, you'll implement it and it doesn't quite work out as planned. So that's where you keep monitoring. If the accommodation's not working out, then you start back over, start identifying new accommodations. And you want to keep working through that process so that eventually you can have something in place that works. And then again, like I said, you want to make sure you're documenting everything you're doing throughout that process. So let's say you have an accommodation that you're shooting down. Um, when you're looking at that, you do want to make sure that you're gauging it against an undue hardship. So let's say, for example, your small retail store with 20 employees, company has limited revenue, probably can't afford to install a $100,000 elevator. But you should look at other accommodations. So maybe you're moving that person's office to the first floor so they don't need the elevator. Things like that can still be done. If you are outright refusing it, for the burden of, or to meet that burden of an undue hardship, you need to look at the totality of the situation and it needs to be done on a case by case basis. So things the EOC will look at are things like the size of the company, the resources available, the nature of their business, the cost of the accommodation, the impact on operations and other employees, the structure and composition of the workforce. Trying to win a or prove undue hardship strictly based on it's going to be expensive is a high bar. So a lot of the times you want to look at the totality of the situation. So would it mean a fundamental job alteration? So if you are potentially required to significantly modify the essential functions like a construction worker who can't lift heavy materials, if lifting is an essential duty of their role, you that probably wouldn't be an accommodation, and you could potentially claim an undue hardship in that situation because now you're modifying the essential functions. You're not just modifying a marginal task. There could also be safety concerns. So certain disabilities can potentially interfere with an employee's ability to work alone or operate heavy machinery. In situations like that, you may not be able to accommodate them by putting them in that situation. So in that case, there's a legitimate safety concern. So you could potentially claim an undue hardship there. If a accommodation were to require significant disruption to how the business operates, that one's a little bit harder to prove. But if it would mean constantly modifying your manufacturing process just to reflect one employee, you could potentially claim a undue hardship in those situations as well. So you do want to take a look at kind of the totality of the situation. Another thing that I kind of touched on earlier, but let's say you have an employee and you're looking at reassignment as kind of a last resort for an accommodation. You don't need to violate your existing seniority systems if there's an open position and the employee applies for it. You don't necessarily need to grant them that position over somebody else with higher seniority. Additionally, you don't need to create a new position or anything of that nature. So if you don't have a position available, you may not be able to reassign in those situations. So the accommodation process, again, ultimately, you're going to be engaging with the employee. They're going to identify it. From there, you're going to want to get the documentation you need to show that there's a disability that exists and get an understanding of what their limitations are. From there, you're going to engage with the employee to identify possible accommodations and ideally implement one that works for both the company and the employee. If you are denying an accommodation request, keep in mind that it could result in legal action. So it's always a good idea if you are going to outright deny a request and you don't have any alternatives, it may be worth speaking with legal counsel just so that you can make sure you're dotting your I's and crossing your T's and mitigating as much legal risk as possible, particularly if the employee has documentation supporting their need for accommodation. So like I mentioned before, the ADA process isn't just when they're actively working for you. It also comes into play during the hiring process. Really, it's throughout the employee's life cycle from recruitment through termination. So when you're working on your plan, first and foremost, your job descriptions are probably the single most valuable document that you'll have when it comes to the ADA. Ideally, your job description should outline all of the essential functions. Um, if there are physical requirements, you want to outline those on there, but they're not always necessary. For example, I'm sitting here at a desk in my house. There's not a whole lot of physical requirements. So a job description for my role that outlines I need to be able to lift X number of pounds probably doesn't make sense. However, if I was working in construction or within the labor industry and I need to be able to lift a certain number of pounds, then that would be an essential function and it might make sense to outline it on there. Again, in the interview process, you want to make sure that you're focusing on the job functions itself. You don't want to ask about the disabilities, but if an employee does reach out and they need an accommodation for the interview process, it's recommended to engage with them and see what you can do to try and accommodate. If you use things like pre-employment testing, make sure those tests are measuring skills, not their disability. So in a situation like that where we had a written test as part of our licensing requirements, we would take a look at it and see what we could work out as far as accessible testing formats, whether that was a verbal test or something along those lines, so that we could accommodate individuals that may struggle. And then it's always a good idea to make conditional offers before you start requesting any sort of medical information. Even if you are a company that requires, say, a pre-employment physical, things like that, make sure that you have that conditional offer in place before you start making those requests. And if you do have some sort of a pre-employment physical, make sure that you're consistent across the board and that you're applying the same standards to all candidates. You don't want to get into a situation where you have one employee where they're saying, yeah, you're good to go, even though they have a similar disability, and then turn around and treat another employee with a similar condition completely differently. So as far as managing performance, like I touched on briefly before, so you're not lowering the bar, you're helping the employee to reach that bar. So you do want to hold your employees with disabilities to the same performance standards as others. It's always a good idea that when you're navigating through your disciplinary process, look at if there is a possible need for an accommodation. I had one where I had an employee who was really struggling with coming to work on time. He had a big tardiness issue, and first write up says verbal. He didn't really disclose anything. Second write up, he didn't really disclose anything. On the third one, because I noticed it was kind of a trend, I started asking him, like, hey, is there anything that we can do from a company standpoint to help you out in this situation? Because we don't want to lose you. You're a good employee. Um, and that's when he revealed that he had a disability that was impacting his ability to wake up early in the morning. So what we did was we looked at his needs, we worked with the doctor, got the necessary documentation for it, and then we started looking at, okay, based on the doctor's information, what can we do to accommodate? So what we were able to do is we were able to move him to a different shift. In doing so, we were able to address the issue with him not being able to wake up first thing in the morning. And by moving him to swing shift, we fixed the attendance issue. Now, not every situation is going to work out perfectly like that, but in that situation, it did. And that's why it's a good idea to look at those performance situations and see if there might be an underlying cause. It's a good idea to have those discussions with the employees. You don't necessarily need to ask, hey, do you have a disability that's causing this? But you can approach it from a standpoint of, hey, the company wants to help. What can we do from our end to address this issue? If there are performance concerns and you have an employee with a disability, make sure that you're doing so objectively and have specific examples. Just because there is that higher risk of disability discrimination, you do want to be mindful of making sure that you can prove, hey, this is an issue, this is what happened, here's the examples, as opposed to, oh yeah, that employee is just a low performer. And you want to be consistent across the board. Um, I mean, in my background, I was working in a union environment, and past precedence was essential. So I would have to make sure every disciplinary action was consistent with all of the ones before it, or I'd lose a grievance. That's on a lower scale, but when you're dealing with potential protected classes such as a disability, you do want to be mindful of making sure that you're consistent across the board. That way, if down the road you're ever forced to defend why a decision was made, you can show that consistency. Things you want to avoid. So taking adverse action immediately after accommodation requests, even if it's unrelated to the accommodation itself, you want to tread carefully because there's always going to be that timing element. Um, when we see it a lot more on the workers' comp side, but if there's any sort of a sudden action that's taken right after an accommodation request, it's going to potentially look like it's connected. So it may be worth building in a little bit of a cushion or looking at how you want to navigate through that to make sure that A, it's truly legitimate, that you have the documentation to defend it, and that you can show it's not connected to that accommodation request. Again, when it comes to disability related absences, you do want to tread carefully, particularly if that's the sole basis for a termination. So potentially an employee may need to miss work due to their disability. In situations like that, it might be worth looking at placing them on a leave of absence or something so they can get into a position where they can better manage their disability. But if you have an employee who comes to you and says, hey, I have this disability, it's causing issues, you want to tread carefully before you terminate in that situation. However, the ADA does not require you to accommodate frequent, unpredictable absences. So if you have an employee who's just constantly showing up late, not calling in, things like that, you can still discipline in those situations. However, if they're needing certain days off for treatment, things like that, you do want to try and work with that employee. Another thing, you don't want to make assumptions about capabilities based on disability. So tying back to that security officer that we hired who was missing a leg and had a prosthetic, one of my recruiters was actually ready to cut the employee loose the moment he came in for it because he said, "Hey, he's got a prosthetic. How's he going to be able to patrol?" So I had to coach my own recruiter on, "Hey, can't do that. That's possibly discrimination. And B, we don't know whether or not he can do that. He says he can. We should give him the shot." And we were able to work with the employee, and he ended up actually getting promoted into a supervisor. So had my recruiter just ran with his assumptions, we would have potentially missed out on a great employee, and we also would have created some liability for the company itself. And then again, you want to avoid disclosing an employee's disability to coworkers or supervisors without necessity. So medical information is protected. So in a situation like that, where even if you do need to discuss an accommodation with a supervisor so that they can help implement it, you don't necessarily want to share the specifics of the medical information. So handling medical examinations and certifications. So like we covered before, prior to the offer, so that could be during the application process, that could be during your initial interviews, you want to avoid making any sort of disability related inquiries or requiring medical exams. Doesn't matter what position it is. You want to steer clear of that until you've had that offer made. Once you've extended that conditional offer, then you can potentially start making those inquiries. For example, if you require pre-employment physicals, once that conditional offer goes out, you can then make the physical happen. But you do need to make sure that that's done for every employee in that same job category. You can't just arbitrarily say, okay, that employee's getting a physical, but the other five aren't. And then once the employee actually starts, medical exams must be job related and consistent with business necessity. So in situations like that, you do need to have objective evidence. It can't just be, oh, well, I think their disability might be a safety risk. You need to be able to articulate why that poses a safety risk. So if you have an employee who they have a seizure while operating heavy machinery, that's pretty conclusive. I mean, that's objective evidence that there might be a safety concern. If you have an employee who they just finished their treatment for their disability and they're coming back and you're worried about something happening, that's probably not going to, unless they missed a prolonged period of time, depending on the disability. But again, it does need to be job related, does need to be consistent with business necessity, and it does need to have objective evidence for it. When you're dealing with medical information, best practice is to keep that separate in a confidential file and try to limit access as much as possible. So it should be kept need to know. Disclosure should only be limited to individuals that would genuinely need access to it. Typically, that's going to be just HR. Managers, supervisors, they don't need to know the nitty-gritty of it. If there's an accommodation, HR can communicate that without providing that medical information. So the ADA doesn't exist in isolation. It does have a lot of interaction with other employment laws. It also interacts with your own internal policies, so it can be kind of tricky to navigate. One of the biggest kind of elements that it interacts with is the Family Medical Leave Act. So for those of you that aren't familiar with it, it is required to have 50 or more employees before FMLA applies, but it provides up to 12 weeks of unpaid leave for serious health conditions. Under the ADA, leave can be an accommodation. So potentially, if you have an employee who's going to be out for 12 weeks on FMLA due to a disability, they may also have protections under the ADA. Where it gets tricky is the ADA doesn't have a hard number when it comes to leave. FMLA is 12 weeks. ADA, it just needs to be reasonable. So in a situation where an employee is covered under the ADA and FMLA, once those 12 weeks are up, potentially the employee could be eligible for additional leave. So you don't ever want to immediately terminate an employee when FMLA expires. Typically, it's a good idea to assess, okay, when can they return? what's their prognosis to return. So for leave as an accommodation, potentially an extra week or two of leave beyond the 12 weeks, that might be reasonable. However, if the employee's coming back and saying, I won't be able to return for another year, then you can look at that and make that determination of holding their position would be an undue hardship. The one element where the ADA would not come into play when it comes to leave would be if it's an indefinite leave. So indefinite leave where there's no defined return date, anything like that, is not considered an accommodation and would likely constitute an undue hardship. So in situations like that, that would not apply. But again, it's always a good idea to look at their FMLA eligibility, start that process as soon as you become aware of their need for it, and then start evaluating whether or not they'd qualify under the ADA. If they do, once that FMLA is exhausted, then you'll want to reassess the accommodation process. Again, you want to document both of those processes separately, just so that you can make sure that you have the paper trail to defend the decisions that were made in both regards. So another one that comes into play is the Pregnant Workers Fairness Act, or the PWFA. So that took effect in 2023, and it's kind of an interesting one. So prior to 2023, pregnancy by itself was not considered a disability. However, if you had an employee who they were pregnant and then they developed a disability as a result of the pregnancy, so like gestational diabetes, things like that, that would be covered under it. So it created kind of this gray area where sometimes pregnancy is accommodated or covered, sometimes it's not. And the Pregnant Workers Fairness Act really served to close that gap essentially. So it does require reasonable accommodation for physical limitations related to pregnancy, childbirth, and related medical conditions. Similar to the ADA, it applies to employers with 15 or more employees. The big exception is there's no undue hardship exception. Um, so when you're navigating through that, potential accommodations could be allowing an employee to sit if they're working at like a cash register or things like that. Um, Allowing them access to water, or potentially temporary reassignment to a safer environment. So if they're working with chemicals that could potentially harm the development of the child, temporarily reassigning them to a safer environment for the duration of the pregnancy could be an accommodation. Again, you don't ever want to force an accommodation on somebody. So just because they're pregnant, you can't just say, hey, we're reassigning you. But you should engage with that employee, let them know, hey, you could potentially, or you do have the right to an accommodation if needed, and let the employee kind of guide that discussion. Um, from an employer standpoint, because of this, they're so similar. So the PWFA and ADA, realistically, the accommodation process is the exact same. Um, it's a good idea to have kind of a unified accommodation process where an employee expresses the need for an accommodation and why, uh, and then the company works with them on that. You also want to make sure that you train your managers on both laws so that they understand what the needs are. And then you'll want to make sure that you're documenting which law applies to each accommodation request. So if it's an ADA accommodation, you'll want to make sure that somewhere in your documentation you're pointing out that this is due to a disability versus pregnancy accommodation. Some companies, they'll create separate forms. Some will use the same form and just have a checkbox. As long as there's some way you can identify what the accommodation was for and why. So it's also a good idea to have ADA policies in your employee manual. So this is a great way to communicate these rights to employees, make sure that there's a process that's outlined, and really make sure that everybody's on the same page. So some essential components are clear statement of ADA compliance commitment. That's going to be your first line of defense to say, yep, we're aware of the ADA, we're going to do our best to comply, and that's going to be communicated to everybody. You want to define the disability. Make sure that that's consistent with current laws. That way, everybody's operating off the same definition. Disability can mean a lot of things, but by having that clear definition in there, you're going to make sure that everybody's operating from the same starting point. You're going to want to detail your accommodation request procedures. So designate who the point of contact would be, who's going to own that. what information might be necessary. By having everything in there defined, employees can look at it and go, okay, I need to reach out to human resources for this. You want to explain the interactive process so your employees understand, hey, this is what I need to do. This is the type of information that's going to be requested. That way, going into it, they have an understanding of what's going on. You also want to make sure that you have a clear anti-retaliation provision in there. Employees need to understand that they can't be retaliated against, or that the company is committed to not retaliating and addressing that, and who they need to report it to if they feel like they're being retaliated against. You also want to make sure that you stress confidentiality. And then again, you want to make sure that you have contact information for your ADA coordinator. A lot of the times it's going to be HR, but if it's not, employees need to know who they need to talk to in order to start that process and navigate through it. Again, that doesn't shift the burden away from supervisors. Supervisors and managers should still be aware of the reporting structure, what to do if they receive a request, how to get that information to the correct person. But having that in there, you can help control that information and make sure that your supervisors aren't unnecessarily receiving a ton of medical information. So this is kind of more of a hot button one. It is still tied to the ADA, but particularly in Missouri, there's been a huge uptick in lawsuits against websites or companies because of their websites. Essentially, the websites aren't being structured in a way that they're accommodating to individuals with disabilities. And an individual in Missouri is currently going after a lot of different companies and working his way across the state. So we did throw this in here just to emphasize that, it is an important topic and you're going to want to make sure that your website is in compliance. It's a good idea to use the Web Content Accessibility Guidelines as kind of your benchmark for compliance. So these include things like alternative text for images, so that if they're using a text-to-speech program, it can identify what that photo is of and then narrate it accordingly. Allowing keyboard-only navigation, making sure that your website's compatible with screen readers, providing high color contrast options. If you're providing multimedia like videos, providing captions and transcripts, making sure that the text size can be zoomed in or otherwise adjusted. In doing so, you're not only going to reduce legal risk for your company, but it's also going to improve the usability for all users. So you never know which one of your clients may need a little bit of help with accessing your website. So if you make sure that your website's a client or compliant ahead of time, you're expanding your ability to connect with more customers, which is ultimately going to benefit the business in the long run. So as far as best practices, again, every company can make mistakes. Even if you have the best of intentions, things can sometimes happen. But we did want to outline a couple of kind of the big mistakes that we see and kind of the common pitfalls and give you some strategies to avoid them. So probably the biggest one is a delayed response. So if an employee comes to you requesting an accommodation and you don't get back to them, or you take forever to engage in that process, it just increases the likelihood of that employee then deciding, okay, the company doesn't care, they're not trying to engage in the ADA process, so therefore we're going to settle this in court. So ideally, if you do receive a request, connect with that employee, communicate with them, let them know, hey, this is what we need, this is what we're doing, this is where we're navigating. Keep communicating with them. Which ties in with point two, poor communication is another pitfall. So if you're not engaging in a meaningful dialogue with the employee about an accommodation, it makes it more likely that accommodation is going to fail. When I was trying to work with that employee that needed specific shoes, I was having a lot of back and forth between the employee, my management team, the client management team, going back to the employee saying, hey, this will work, this doesn't. But I was constantly in communication with everybody to assess, hey, does this work? Does this not work? What can we do? What needs to be changed? A lot of back and forth. And then even after it was implemented, I was still following up with them to make sure, hey, is everything working out? Is everything good? And then I was documenting everything. If you're not communicating with everybody, it's going to come across as Company doesn't really care. If an accommodation's starting to fail, you're not going to be aware of it because you're not connecting with that employee. And then it's just going to create further issues and it's going to make it seem like the company's not operating in good faith. Again, inadequate documentation is another huge one. Even if you're willing to accommodate an employee and you modify their schedule or you allow them to telework or what have you, if you're not documenting that process, you're setting yourself up to fail. Because let's say down the road there is an issue and you need to defend that decision that was made or show that that accommodation was actually implemented. If you don't have the documentation to show that, you're not really going to have a whole lot of evidence of what took place that you could use to defend it. Yes, you might be able to testify and things like that, but documenting ahead of time is going to save you a lot of headaches on the back end if your decisions are ever called into question or you need to defend that situation. And then retaliation is another big one. So if an employee accommodates or requests an accommodation or they assert their ADA rights and then you turn around and write them up immediately after, or you start trying to performance manage them out without looking at the ADA process, or you just terminate them for filing, you're going to open yourself up to a lot of risk. And there's going to be some serious penalties associated with that. So in a situation where, let's say you have an employee, they're a low performer, and you've already drafted the disciplinary during that meeting, they disclose they have a disability. Technically, that disciplinary action started before they made you aware of the disability. So you have a pretty good standing there, but if you were to turn around the next day and write them up again, probably going to open up some risk. So it's a good idea to look at that timing, look at the performance management, make sure that you're operating off a fair standard and giving them the chance. Similarly, if you implement an accommodation and maybe there's a slight drop in performance initially as they're adjusting, it might be worth connecting with that employee, working with them, seeing if that accommodation's working. And then once they've had a little bit of time to kind of transition, then looking at the performance aspect as opposed to, oh, first day on the accommodation, it didn't immediately fix the problem, so we're going to performance manage it. So you always want to be mindful of the timing of that. Again, you want to make sure that you're training your management team. First and foremost, managers, supervisors, they need to be able to identify when a request might trigger an ADA obligation. So, like I covered before, employees, they're not going to come to you and just say, hey, I have a disability, I need an accommodation under the ADA. I don't think I've ever had an employee be that explicit with it. Usually they'll mention, hey, I've got this condition, it's impacting my ability to work, or sometimes you'll be asking, hey, what's going on? And they'll mention their disability in the context of how it's impacting them. In a situation like that, you need to be able to recognize that so that the company can then engage its ADA process. Again, you want to train managers, supervisors on that interactive process. Ideally, you want to have a protocol outlined for how you have those discussions, what's discussed, what's documented, how it's documented. That way it's clear for everybody. It's going to make sure that everything's consistent. Sometimes you do have to engage with supervisors to try and find a workable solution. So a lot of times it can't just be handled solely by HR. So it's important for managers and supervisors to be aware of that process and how it works. And then you're going to want to have clear guidelines on how medical information and other sensitive documentation is handled. So you want to make sure that you're not oversharing. Just because you have an accommodation in place doesn't mean everybody in the company needs to know the specifics of why. So you want to be mindful of that aspect of it. Again, the main reason that we wanted to do this is really it's going to help you build that culture of inclusion and compliance. So try to lead by example. Demonstrate that you're committed to following the ADA by participating in training, speaking about inclusion, and really engaging in the accommodation process when appropriate. Again, you want to stay informed. There's some great resources out there as far as evolving ADA regulations, case law, and even best practices in terms of disability inclusion. The Job Accommodation Network or AskJan.org is probably one of my favorite resources right now because you can literally search by disability or what the limitations are, and it'll give you a list of possible accommodations. So you can then look at that and it'll give you kind of a baseline of, hey, this might work, this could work. Maybe I'm not looking at it this way. So taking the time to identify those resources and really tap into them are going to be huge, and you're going to see those dividends. Try to empower your team. So provide your managers with those resources. Give them the authority to effectively respond to accommodation requests or if there are issues with inclusion. Ultimately, by committing to a culture of inclusion and compliance, you're going to be protecting your business from costly litigation. You're going to be protecting your employees' rights and dignity and your company's reputation and brand. Ultimately, it's going to help you create an innovative and diverse workforce. You're going to have better engagement and loyalty. And ultimately, it's going to not only help improve your products and services, but it's also going to potentially expand your customer base as well. Particularly tying back to the website side of things, if your website is more inclusive, more people are going to be able to visit it, which potentially could lead to a wider customer base. Ultimately, the investment you make in ADA compliance today isn't for today. Really, it's going to benefit you long term. So with that, I do have a couple minutes left. So I wanted to kind of open the floor to questions. Kyle, were there any questions you weren't able to answer in the chat?
No, I don't think so. We did receive one question. I don't know if you wanted to add on it to it at all, but one of the attendees asked, as an employer, are we required to proactively inform pregnant employees about their potential eligibility for workplace accommodations, even if they haven't expressed any challenges or made any requests?
Yep. Generally speaking, you don't have to outright approach them. You should have something in there that outlines, hey, these are your rights under the PWFA in your handbook, something like that. So they have access to it. You don't necessarily need to go up to them and say, hey, you're pregnant, here's a flyer. But it could be beneficial if you do start to seem struggling to engage with them and say, hey, if you run into any issues, we have this accommodation process in place. As a pregnant worker, potentially you could be eligible.
Kyle and Mitch, this is Laura. I had a question about the 15 employees because I know that some of the businesses that have been sued throughout the state do not have 15 employees, and yet they're still being sued about their website not being compliant. How is that happening, and why are they successful with their lawsuits?
Yep. So the 15 employee mark is strictly for your employees. So as far as a company wise, if you need to provide an accommodation, that's where that 15 employee mark comes in. My understanding as far as the more broader aspects of the ADA is that would apply to any business owner. So things like storefronts not having accommodations, ramps, things like that. I believe that opens up regardless of number of employees or size of the business. Kyle, do you have anything to add on that?
No, I think you said it appropriately. It's a website ADA and HR inside your organization are not necessarily applied the same way. So we're speaking specifically to ADA through your HR, through your organization. The ADA for website accommodation does not have that same limitation.